again, Mr. Clark. One last question. I sort of get where you're coming from, but one last question on this article here in the paper. It just says, if I could just read one or two sentences here. Many prosecutors eventually become defense attorneys, but MacLeod says she would have a hard time defending people like the ones, Laurie, she has prosecuted. And I know you go on to talk about one particular case, but the sentence doesn't say she would have a hard time defending people like the one that she just prosecuted. You talk about, says she would have a hard time defending people like the ones she just prosecuted. And then I asked you about these cases, the court-appointed ones, and you said, hey, that's my job. To the best of my ability, I'll take them all. So I don't understand the difference between, on one side, you have a difficult time defending some of these people, but then when you get the court appointments, you'll take everybody.
Well, I think that my answer to that is, I'm not sure the date of that article, I think it was 2002 or 3.
I'm not sure.
At that point, I was a prosecutor, and I would have had a hard time defending some of the ones that I was prosecuting in the office of the attorney. Listen, I mean, domestic violence can be a terrible crime. When I left the district attorney's office, I became a defense attorney, and as a defense attorney, I took on a new role. And did I have a difficult time, perhaps emotionally, maybe with some of those cases? Maybe, but it didn't matter. My job was to defend them zealously, and that's what I did, and that's what my record would show. If it is interested at all in the cases that I had defended, there were difficult cases that I had defended them zealously.
And I appreciate that. But I'm just saying, there are a lot of serious domestic violence, no question. It's very, very serious crime, but whether it's robbery, whether it's assault and battery, breaking in and entering in the nighttime, those are all serious charges. Also, this is just my last question. Based upon what you just said, if you could give me a little insight, if you want to help us out, this is sort of a different type of question. How you just answered that question. If somebody comes before the council who's just a prosecutor, doesn't have the experience on the criminal side representing defendants the way you have, based on your last answer, I get the sense that maybe if somebody comes next week who's just a prosecutor, they may have a tough time, as you did, emotionally and everything else, given the defendant maybe a fair shake. Do you think we should be, as the council, and I know you're not here to advise us, but do you have any opinion as to whether or not judges would be better off if they had not only prosecutorial experience, but also experience representing defendants? Because most of the folks, I don't want to say most, but close to 50% of the people who come to before us nominated in the district court over the last 20-some odd years, most of them are prosecutors and don't have, at least you have both experiences. Do you have any opinion on that in general? Because last time you have gone in front of these judges, both as a district attorney and as a defense attorney. So you have a wealth of experience and knowledge. I don't have that because I don't go to court. I go 3 or 5 times a week.
It's a good question. I think a balance is good. I think that the balance that I've gained by being both a prosecutor and a defense attorney and in private practice before as a prosecutor has given me the kind of balance that you might look for as conflict. Can I say that a career prosecutor is somebody that you don't want to put on defense? I don't think I could say that. I mean, they may have that ability to, when they got on the bench, that they would be a fair-minded judge as well. I'm appreciative of the fact that I've done I've been in various numbers so that I've seen that balance is important in terms of what I need today.
And last question, Congressman. In juvenile cases, you talked about abuse and neglect cases. And who do you represent? Was the child?
I represented children and parents in those cases. When I first went to private practice, I thought that I would take more of those cases. Ultimately, I decided to not focus my practice on those cases and to go back to criminal law.
No further questions. Thank you.
Thank you, Councilman.
Thank you.
Before I dismiss you again,
my duty to publicly state that Judge Merrigan should have recused himself from this hearing on 2 counts. 1, because he received $250 from the nominee, and 2, he represented a client recommended by the nominee, a case still pending, in which he will receive a third of the referral fee from the judge's law office. This is in violation of conflict of interest law. I believe it's 268A. The state in that provision, Master Law, that if there is a financial benefit, then the individual will recuse himself. And just for the benefit of those, I'm not a lawyer, and for people who are not a lawyer, I will just refer to myself. As a city councilor, when my late husband was a firefighter, I recused myself. And I even left the room when the budget would come up, and so there would be the appearance. And that's one of the things under 268 is the appearance. And so I do want to put that on the record because I still believe that Judge Merrigan should vote on this nominee. He recused himself from that, and there was his tenants. He shared office space, and he said here in public record that they were friends for over 20 years. And I think that this is even more. I think this is more credible to recuse, and I would say that in violation, I would advise, I'm not a lawyer, but I would just take that advisement that I was Judge Merrigan.
Let me just respond to the record, since we're on it. The issue under the conflict of interest statute 268A is whether or not somebody has a financial interest in the issue before the body on which the person is to be voting. And certainly I have no financial interest in the outcome of whether or not she becomes a judge or she does not become a judge. But out of an abundance of caution, I had a conversation with legal counsel at the Ethics Commission who advised me that I don't have a conflict of interest. He advised me that because there are facts and circumstances related to this that might give rise to an appearance of conflict, that the section of the statute that I referred to in my letter, 268, I think it's 268A, 23B, negates any reasonable basis to conclude that there is an impropriety by making a public disclosure. That's the purpose of the letter here today. I've made a public disclosure in accordance with the requirement of the statute and in accordance with the requirement of the legal advice and opinion that I have obtained from the Ethics Commission.
There is no mention in this letter that you received money from the person that you're cheering.
I'm not going to debate with you.
I'm not debating. I'm telling you, couldn't have been cheering?
Ask your question. Ask your question.
No, this is not. I asked you.
Ask
why
your
didn't
question.
you refuse yourself because you received money?
Ask your question.
That's a financial gain.
Ask your question.
To you?
Ask your question.
I'm through.
All right.
I have questions for you.
Well, then you get to this.
I enjoyed the time with you and the time that you gave me. And I do want to say that I do want to put on the record that you provided the letters of endorsement for you to the JNC, which previous candidate that you lost out on that position did not. That's transparency, that's honesty, and I want to note that on the record. I appreciate that. Some of the things that have come up that we didn't talk about when we met, and I wish we had, because I have some questions about what has come up. I mean, one of the things that really concerns me, and Councilor Manning was so thorough, I don't think there's much left to speak on, and thank you for this and for Councilor Ainella's remarks. But what got me about this, and I know it's a long time ago, it was 7 or 8 years ago, but it was said, and sometimes it was quoted, but you admit that you said it, and proving guilt beyond a reasonable doubt is a very, very high hurdle, and that's one thing. And let me go on, and then